We will move now to our first presentation of the day, which is on prescriptive easements. Our first presenter is Sharon O'Callaghan. Sharon is Divisional Manager in the PRA and currently leads the Priority Customer Review and Prescriptive Easements Unit. Sharon's presentation today will focus on providing clarity on prescription law timeline and assisting you in lodging a successful application. Welcome, Sharon. So thank you for joining us today. So whenever you're ready, I'll hand over to you there.
Yeah, I'll just go and share my screen now. Can you see that, David?
I can indeed, yeah.
Great. Okay, good morning, everyone. My name is Sharon O'Callaghan, and as David just stated, I'm the Divisional Manager over the Prescriptive Easements Unit. So today, I hope to give you a brief overview of the process of applying for prescriptive easement and the changes in the rules that take effect later this year. So during this morning's presentation, I will explain the characteristics of an easement and a profit of prendre. I'll go through the prescription law timeline, in particular the changes that are taking effect from the 1st of December 2021. I'll go through the process of making an application and how we process this application in the PRA. And finally, I will discuss some common issues which may lead to an application being rejected, and we'll discuss how an objection may affect your application. So firstly, to register an easement, there must be a dominant and a servient tenement, and they must be held in different ownerships. The right that you're applying for must accommodate the dominant tenement. And it's important to note that the right attaches to the land, so therefore all future owners must also benefit from this right. And finally, the right must be capable of forming the subject of a grant. A profit, on the other hand, is a right to go onto another person's land to take natural material from it, for example, to cut timber or turf. Examples that are pertinent to a dominant tenement would be mineral or turbary rights. Those that are appendant to the land could have been attached by operation of law, but it's doubtful if such profits exist in Ireland today. And unlike an easement, a profit can be held independently of any dominant tenement, for example, fishing rights. So historically, easements could be acquired by common law, Doctrine of Last Modern Grant, and the Prescription Act. At common law, a claim could be based on user dating back to the year 1189, but in practice, courts have accepted evidence of 20 years continuous user since living memory. Under the Doctrine of Last Modern Grant, the presumption is that a grant was made after 1189, but subsequently lost. And finally, an easement could be claimed under the Prescription Act 1858 for a user period of 20 years for an easement and 30 years for a profit. So under the Law on Conveyance and Law Reform Act 2009, easements established under common law and Doctrine of Last Grant were abolished. There was only one single statutory method of prescription, and that was retained, and that was Section 35, which states that an easement can only be acquired by prescription upon the registration of a court order. Legal title would then be required by registering the court order in the land registry for registered land, or in the registry of deeds for unregistered land. And just note the user periods for both an easement and a profit of prendre under the new 2009 Act are 12 years where the servient owner is not a state authority, 30 years where the servient owner is a state authority, or 60 years where the servient land is foreshore. And all claims to an easement under this Act should be based on an uninterrupted user period commencing after the 1st of December 2009. However, this scheme led to difficulties with solicitors on closing of sales, as many purchasers were not willing to close without the benefit of a court order duly registered in the PRA for rights claimed by prescription. So subsequently then, the Civil Law Miscellaneous Provisions Act 2011 amended the 2009 Act, and it provided under Section 37 for an additional method of applying for prescriptive easement. Applications could now be lodged directly to the PRA under a new Section 49A of the Registration of Title Act 1964, without the necessity of obtaining a court order. Just to note that this process is only for non-contentious cases though. If the dominant tenement is unregistered, a first registration application must be made at the same time. And Section 38 also extended the transition period for applying under the old law, and it allowed a claim under the old law to be brought before the 1st of December 2021. So just to summarise here, a prescriptive easement or a profit a prendre may be acquired on foot of a court order under Section 35 of the 2009 Act, or by lodging an application under Section 49A of the 1964 Act. An application that is lodged prior to the 1st of December 2021 must be made under the old law, whereas an application made on or after the 1st of December 2021 must be under the new law and the new user period. And just to note, this has been communicated by the Law Society to its members on a number of occasions. If you intend to lodge an application prior to the 1st of December, I would urge you to lodge this as soon as possible. We are currently running a high rejection rate of 78%, and in order for an easement to be registered under the existing law, a properly granted application must be received by the PRA prior to the 1st of December 2021. However, issues that may be encountered under the new Act are a claim against state property or foreshore. In this case, the new user period for such claims are 30 years and 60 years respectively, incapacity for some of the 12-year period, and finally, an interruption or a break in continuity of use. So, on to making an application to the PRA. So when you lodge an application with us, you're going to need a Form 17, and the current fees are €130. The Form 68 affidavit must be made by the current owner of the dominant tenement. An ITM map should be lodged showing the full extent of the easement, and I'll go through the types of maps that are acceptable for registration in just a few moments. If you're a personal applicant, you will need to lodge an ID form, and our Legal Office Notice 5 of 2010 provides further details on this. And finally, as I stated before, if the dominant tenement is unregistered, a first registration application should be lodged at the same time. So now I'll briefly run through the parts of the Form 68 affidavit itself. So paragraph 1 should give details of the current holder of the legal title. If the property has been sold, the purchaser must apply. Exceptions to this are applications by a personal representative to facilitate a sale. If the dominant owner is a company, the affidavit must be made by the company secretary. An affidavit by a company director who is authorised to swear the affidavit on behalf of the company and has the necessary means and knowledge to do so is also acceptable. And we don't accept affidavits from receivers, mortgagees in possession, power of attorneys or liquidators. And just note that the period of use should also be stated in paragraph 1. In paragraph 2, this sets out details as to how and when the easement was acquired. So in this paragraph, we look for a good degree of detail. And just note that a bald statement of user for the requisite period will not be sufficient to ground a claim. And none of the averments that are listed here should be omitted from this paragraph. Now onto the schedule. So the first schedule should contain a description of the easement or profit a prendre, and it should reference the map lodged. And there should be no ambiguity between the description in the schedule and the map lodged. So that is to say, if you refer to a right coloured yellow in the schedule, the marking on the map should also be coloured yellow. The second schedule should describe the dominant land by reference to the folio number if the land is registered, or if the land is unregistered, by reference to the map lodged. Again, an application for first registration should be lodged in this case. The third schedule should contain the names and addresses of all the servient landowners. The onus is on the applicant to provide up-to-date names and addresses for the owners of the servient property. If the registered owner, for example, is deceased, these details should be provided along with the details of the personal representative, the next of kin, or the solicitor acting in the estate, administration of the estate. If the surveying land is unregistered and the owner is unknown, the applicant should show all the relevant searches that have been carried out. If the owner cannot be established, our office will issue guidelines regarding a newspaper and site notice, but only when we reach the notice stage. So now on to the maps that are acceptable for use. If you lodge a hard copy Ordnance Survey Ireland map product, you must lodge an original Land Registry compliant map product. If you lodge a PRA map product, you can choose from either a title plan, an official map search, or a special registration map. And just note that if the right that you're applying for traverses over several folios, you should consider using a special registration map as a cost-saving measure. So now I'm going to quickly run through how we process the Section 49A applications when we get them into the PRA. So the applicant or their solicitor will lodge an application to us. We will then read all the documents, and if all is in order, we will issue notices to the surveying owners. If no objection is received within the allowed time frame, the application will be completed and the prescriptive easement will be registered on the folio. However, if a valid objection is received, we will ask the applicant to withdraw the application, as this procedure is only for non-contentious cases. Alternatively, though, we may refuse the application, which can then be appealed to court. And as I stated earlier, our current rejection rate is 78%. And some of the most common errors that lead to an application being rejected are listed here, and I'll go through them now for you. So firstly, an incomplete Form 68. For example, here, some of the averments may be omitted from paragraph 2. The applicant no longer holds the legal title to the dominant element. The map lodged does not show the full extent of the easement, or it doesn't correspond with the first schedule of the affidavit. The affidavit does not provide a full history of use. The surveying owner's names are not provided. The surveying lands are unregistered, and no further details on searches have been provided. A hybrid affidavit is lodged, for example, an affidavit that could be declared and not sworn. And just to note, if there's evidence of previous consent to the right that you're applying for, then an application under Section 49A is not the correct route to register this easement. So on to objections. And generally, the PRA position on objections is that they will defeat a Section 49 application. However, an application could always still be made to court under Section 35 of the 2009 Act. And in certain circumstances, though, we may be willing to accept a reconstituted application. So for further information, I'd refer you now to our practice directions, our legal office notices, and our mapping guidelines, which are all available on our website. And once again, if you're considering lodging a prescriptive easement application, I would encourage you to lodge sooner rather than later, particularly in light of our high rejection rate. And just to give you a time frame, an application that is in order can normally be processed within 3 months. Again, this is obviously dependent on receiving no objections to the registration. And to assist you further in lodging a correct application, you may wish to view our Prescriptive Easements video, which is also available on our website. And if you're considering lodging a large number of applications or need any further assistance, please feel free to contact me at any stage to discuss this. So thank you very much for your attention this morning, and I'll now pass you back to David.